Welcome back. Moving to this now, on a Thursday, the Democratic Alliance filed an urgent application to interdict the implementation of the 0.5 percentage point increase on VAT at the Western Cape High Court. The party has asked the court to suspend the implementation of the hike pending the outcome of the review application. To help us make sense of the application, we are now joined by Thomson Wilks Attorneys Director, Bartho van Tonder. Bartho, a very good morning to you. Thank you so much for making time for us this morning. So it's a two-part application, one on an urgent basis to interdict this decision or the implementation of the 0.5% VAT hike. Could it be argued that the Democratic Alliance would be jumping the gun here, considering that the commitment that has been given by the Minister that following the recommendations that have been adopted, that there'll be a 30-day period where they'll try to see whether or not they are able to find other revenue by not increasing VAT by 0.5 percentage point. What's your take on this?
Well, whether they might be jumping the gun, it's approaching court urgently is always a very sensitive thing to do. I think the risk that they have and that they're probably contemplating is that if the minister doesn't do it, then the VAT increase should take effect on the 1st of May. So at that point, it might be too late. So I think the thinking behind it is to anticipate the possibility that he doesn't make any decision that might withdraw the coming into effect of the VAT increase and to try and preempt that from happening.
Yeah, and sticking on the VAT increase element and also the application that they've brought, and I know this is part B of the application, I'd like us to deal with that just quickly. So the Democratic Alliance is also attacking Section 7, subsection 4 of the VAT Act. And their argument is that it is unconstitutional in that it gives the minister the powers to be able to implement a VAT increase for a period of 12 months without the consent of Parliament. Just help us make sense of that. What does that mean, and what should the role of Parliament be, according to what the DA is arguing, when it comes to a tax increase?
Well, yes, as you say correctly, their position is that they're challenging the constitutionality of that section, Section 7.4 of the VAT Act. They say that the minister shouldn't have the power, being part of the executive, to unilaterally increase or change the VAT rate without Parliament's approval. What the Act provides for at the moment is that the minister can make a change with the announcement of the budget and give a date as to when the VAT rate change would take effect. In this case, he did so from the 1st of May, and there's nothing that Parliament can really do about it. The section provides that within 12 months, Parliament needs to pass legislation which effectively endorses that change. And what the DA is saying is that if that doesn't happen, then the minister's decision would be unchallengeable effectively for 12 months. And they say that that's unconstitutional because the Constitution exclusively provides that kind of power to make legislative changes, because it specifically refers also to Section 7.1, which is where the VAT rate is specified. So what the minister would effectively be doing is amending legislation unilaterally by making an announcement without Parliament's oversight. So they say that this is an unconstitutional procedure.
Yeah. Are you able to speak to us maybe at the time that when this particular legislation was crafted, was the idea behind it that in the case of an emergency, that the finance minister would have such powers to be able to accumulate enough revenue for the state in the moment of crisis using this particular legislation, Section 7, subsection 4 of the VAT Act? What was the thinking behind it?
Well, yes, I mean, what the thinking was behind the VAT Act when it was passed, I think it was in 1991. So that was obviously before, the constitutional democracy and the constitutional supremacy. What the thinking was to allow the minister to do that, it might be precisely as you say, for practical reasons. It might be very difficult in an emergency situation, as you say, if there's a revenue shortfall, to have to make a decision quickly which in a sense circumvents the ordinary procedure of Parliament being able to pass legislation which will amend the VAT Act or the rate of the of taxes, and that might be the reason. Whether the motivation behind it at the time would justify its retention as it stands, that remains to be seen. The risk, I suppose, and what the Constitution obviously tries to prevent is an abuse of state power. And one can argue that he has the power to increase it, and there's not going to be anything that anyone can really do about it, regardless of what rate he increases it at. So there might very well be practical considerations behind it. But one has to, of course, balance that with the power that affords someone that may not want to be abused.
Yeah. So just help me also try and make sense of this as well. So the minister has the power to increase the VAT unilaterally without the consent of Parliament for about 12 months. What happens after the 12 months?
Well, if Parliament doesn't pass legislation to uphold that change or to endorse that change, it would effectively lapse, which means that the VAT rate that decision that is made to increase the VAT rate wouldn't be in effect anymore. It would be in effect for up till 12 months until Parliament passes legislation in support of that decision.
Yeah, and if the VAT Act Section 7, subsection 4 still remains the same at the end of that 12 months, is it, I don't know what the right word for it is, but is it something that is renewable? That the minister would say, I'm empowered by the Act and now I'm deciding that instead of, let's say the last time I said a 0.5% VAT increase, this time I'm going to say a 1% VAT increase. Or does the minister only get that opportunity once in a cycle?
Well, at the end of the 12-month cycle, the section as it reads provides the power for him to make an announcement when the annual budget is announced and presented, and that, as we know, happens once a year. So that would be something that would ordinarily only be able to happen once a year. But if, for example, next year February there's no legislation passed supporting this change, then he may very well in the next budget present a change, and then from there the same procedure would unfold, which can technically lead to an endless cycle without anything ever happening to intervene. But it's very unlikely, because that would clearly be a decision that is then being made against parliamentary will, which would be challengeable for its lack of rationality, which one then can challenge in terms of the Promotion of Administration of Justice Act, PAJA, to say that it's irrational and unlawful and illegal to make a decision which is against the will of Parliament. So I don't think, yes, is it possible? Well, as it stands to the letter of the law, arguably yes, but is it something that is that will be likely to happen and will go untested or unchallenged? I doubt that.
All right. And then finally, the DA is also attacking the procedure that was followed by the Finance Standing Committee on the adoption of the fiscal framework for 2025. They detail the processes that were followed. In that, amongst others, they say the question wasn't posed to the committee after the report, because what had happened is that the report was only finalized after the meeting had ended, and then that report was then circulated. And the report itself was not presented to the committee to have the question and the statement around whether they accept, meaning that whether they adopt the report or whether they amend the report. Do they have a case there?
Well, I think what their biggest challenge probably will be is to justify urgency. That's something that you would need to do in any case, of course, where you're trying to jump the queue, as it were, to approach court outside the normal procedural timelines. You have to prove effectively that there would be no substantial redress, meaning that if you were to come in the ordinary course, if you were to place the matter down on the roll as it would come down in any opposed sort of procedure, then you wouldn't be able to get the relief that you're asking for. It would become without any effect or value. So they have presented an argument that with the VAT increase over 6 months, the implications of that would make it impossible to reverse, and at that point you won't be able to get substantial redress. But at the same time, there's also the argument, of course, that the VAT Act has been around for a long time. And as far as the procedure is concerned, that is something that has also been around for a long time. But specifically, as far as this process that's unfolded 2 days ago is concerned, yes, that can be challenged. But whether one is going to be able to prove that the fact that as much as there may be technical deficiencies to the decisions that were made, whether the support wasn't still there substantively at the end of that process, the court might look at it from a bigger picture perspective. But there does seem to have been some uncertainty that was created specifically due to the double and conflicting messages that are coming out of what the effect was of that adoption of the report. And for that reason alone, one might be able to say, well, there isn't a clear indication of whether the framework is actually accepted or not. And for that reason, it's clear that there was non-compliance with the Money Bills Amendment Act, and for that reason, it needs to be done over again. But of course, there is this issue of what is the cost to the economy and to South Africa if the budget isn't passed and is delayed further again.